We have major breaking news out of the United States Supreme Court. I delayed this video slightly because this is an extremely complicated case, but I'm going to give you the bottom line good news, which is the United States Supreme Court is about, as I predicted several months ago, is going to cut back dramatically on the authority, the power of administrative agencies controlled by the President of the United States. And yes, indeed, that will include the powers, or lack thereof, of the ATF. Stay tuned. We're going to break down the super geeky Supreme Court argument over the Chevron Doctrine in 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in 2 separate categories for the 2024 Gundies Awards out there in Las Vegas, one for top male influencer in the Second Amendment space, and also for top voice of the Second Amendment. I am proud to be nominated and a finalist in both cases. All right, folks. Major oral argument today went on for several hours before the United States Supreme Court. I want to break this down slowly and easily for you so you are the smartest person in the room because it's extremely complicated, involves a lot of overlapping laws. The bottom line is this. The United States Supreme Court in 1984 created a doctrine called the Chevron Doctrine. The Chevron Doctrine in 1984 says specifically that when an administrative agency, a federal administrative agency, controlled by the President of the United States, whether it be the ATF, the FBI, the FDA, the EPA, and so on, those list of alphabet city type agencies, if they interpret the statute that gives them their enabling authority to act, if there's any question about how to interpret the relevant statute or the regulation or anything else that governs that administrative agency and its powers, then courts, that's right, Article 3 courts, including the United States Supreme Court, is supposed to grant deference or to defer to the judgment of those presidential administrative agencies over questions of law. Now, this is actually quite a shocking view from 1984 because keep in mind the basics of the United States, a separation of power concept. Congress enacts laws. The president is supposed to enforce those laws given to it by the Congress. And then, of course, it is up to the courts, Article 3 of the Constitution, to interpret those laws. That is exactly how the entire system works throughout the United States from the beginning of time, or I should say from the beginning of the country. Right? Congress passes a law, the president's executive agencies, such as the Department of Justice, enforce those laws, and then the courts interpret those laws if there's a debate about what they mean. So the Chevron Doctrine, when it was enacted through a court decision called Chevron in 1984 by the U.S. Supreme Court, dramatically changed this dynamic in one narrow area of American law. That area of American law is when the administrative agency, a presidential administrative agency like the ATF, if they happen to be a party to a case, and the issue involves their authority and the statute that they are charged with enforcing or interpreting, if there is any ambiguity or doubt about how that law is to be interpreted, under the Chevron Doctrine, courts, that's right, courts who are otherwise required to interpret the law and apply it, must defer to the president's agency's interpretations of that law. Now, this is terrible on legal grounds, constitutional grounds, and public policy grounds. To begin with, on constitutional grounds, it's a clear separation of powers problem. Because again, the entire concept of Article 3 federal courts is that their job is to interpret the law, whether it be interpreting the Constitution or interpreting federal statutory law. And if there's any debate about it, the courts make that decision. It is their job. Yet here, if in a narrow circumstance involving an administrative agency, the courts, even if they think there may be a better way, and this is what's shocking about the Chevron Doctrine, even if there may be a better interpretation of federal law involving federal statutory law, and a court concludes there is a better interpretation of that law, if that law is ambiguous, which means there's multiple reasonable interpretations of that law, it doesn't matter that a court thinks or what it thinks is the best interpretation of the law. Instead, if it involves an administrative agency's interpretation of a statute, the court, despite thinking that it knows what the law means, has to defer to the administrative agency's interpretation as a matter of deference. This is shocking and a violation of separation of powers 6 ways to Sunday. Not least of which, in addition to the fact that the Chevron Doctrine takes the authority constitutionally away from the courts and gives it to the White House, gives it to the president and to his administrative agencies, it also violates the notion of separation of powers in another independent way. It is taking essentially away lawmaking authority from the Congress, right? Think about it for just 1 second in the concept of, let's say, bump stocks or pistol braces or the framer-receiver rule. Congress enacts a law, the ATF interprets that law, and guess what? Congress never actually banned bump stocks. Bump stocks got banned, and that's going to get overturned, I think, later this term, but set that issue aside. Bump stocks got banned by an about-face by the ATF, an administrative agencies. So essentially, if you think about it from a separation of powers point of view, the president, whose job it is to enforce the law, laws given to the president by Congress, in this instance, the president, the administration, went out and enacted a new law by banning bump stocks when Congress had refused to do so. So in addition to taking away powers from the courts and giving it to the presidency, the executive branch, it also takes away the authority and power of Congress to enact laws or not to enact laws, whatever they deem appropriate, and basically usurps that authority for the president. So 2 separate ways the Chevron Doctrine violates the separation of powers doctrine. But beyond that, let's talk about this argument today. As a side note, I want to let you know, and this is very good news for the bump stock case coming up. In today's argument, Justice Amy Coney Barrett specifically mentioned the rule of lenity. Now, the rule of lenity is very good for the Second Amendment movement because when you deal with the ATF enacts these regulations that if you violate, you get to go to prison usually because they're interpreting criminal statutes. Now, the fact that Justice Barrett and these justices are focused on the rule of lenity, and again, just a reminder, the rule of lenity says this: if you are interpreting a statute, and the interpretation of the statute, and that statute has criminal implications, which means the person can go to prison, that means you apply the rule of lenity. The rule of lenity says if there's any ambiguity about how you interpret that statute, where you might go to prison if you violate that statute, the rule of lenity says that the interpretation must always be in favor of freedom, in favor of the American citizen, and against the government. So the fact that Justice Barrett is specifically referencing the rule of lenity in today's oral argument in the case of Loper Bright, dealing with the Chevron Doctrine, I think is a good sign, not just for where this case is going to come out, but also where I think the bump stock case is going to come out, in a few weeks, and then, of course, in the end of June when these decisions are issued. Now, I also want to give you a couple other arguments that were flagged here that you should be aware of. Very powerful questions by Justice Kavanaugh, who's a very mild-mannered, matter-of-fact jurist. And the Biden administration, the top Solicitor General, was arguing that if this court gets rid of the Chevron Doctrine, and I think that's probably what's going to happen here, and I predicted this many months ago. And if you've been watching this channel, you've been on top of this. And by the way, if other YouTube channels follow me, I'm perfectly fine with that. It makes my life a whole lot easier because it means I don't have to correct mistakes out there that get made. So I'm perfectly fine if people take what I say and run with it with their YouTube channels or on the internet or on the social media. I don't care because, again, it saves me a lot of trouble when people don't screw up and they get it right. So I'm perfectly fine if they take what I say and run with it. I'm good with that. Okay. With that said, very interesting colloquy here. Basically, the Department of Justice says, well, if you get rid of the 1984 precedent of Chevron, you're going to screw up and create instability. Instability in American law. You're going to really mess things up because everyone's been relying upon this for years. And this is really important, what I'm about to say, because this is telling with ATF stuff coming down the pike, including this bump stock ban this term. Justice Kavanaugh is like, whoa. Wait a minute. And this is very important, every 4 to 8 years, Justice Kavanaugh observed, we get a new administration in there. And often those administrations change policies and they change their interpretation. This is sounding familiar. Changing their interpretation of regulations. So Justice Kavanaugh went on to say, let me get this straight. So you're telling me because I'm a court and I have to defer to the interpretation of the federal statute interpreted by the administrative agency. 1 year, it may be an agency that's like good on, could be whatever it is. One way of interpreting the FDA or the EPA law or the ATF law. And then all of a sudden, 4 years later, because you have a change of administration, they change their tune completely. And I'm supposed to defer to the first interpretation, as well as 4 years later, I'm supposed to defer as a court to the second interpretation. He's like, how is that stable? That seems to be the essence of instability in the legal system. Now, I think that's not a random set of questions from Justice Kavanaugh to the Department of Justice, because it is clear that he has been studying what happened with bump stocks and these other cases where you have the Department of Justice, years ago said the bump stocks were legal, and all of a sudden they do an about face and bump stocks are now illegal, which actually proves Justice Kavanaugh's point in today's argument where he's like, look, there's no stability in Chevron. If anything, it's instability because, again, you're allowing, I'm forced, first of all, as a court, to defer to an interpretation by, let's say, a Democratic administration 1 year, and then 4 years later, I'm supposed to defer to a different interpretation of that same statute by a Republican administration. That is insane, was essentially what Justice Kavanaugh was saying. And he goes on to essentially say, and so did Justice Gorsuch and Justice Alito, essentially saying, look, we, the judges, interpret laws every single day, both constitutionally, statutorily, and so on and so on. We always find the best way or the best interpretation of how these goes. Why don't we just apply that as law when there's a dispute? So very powerful Q&A. I think that's a sign that this is going away. The last point I want to make here is that powerful and almost amusing question here from Justice Gorsuch. The big argument by the Biden administration in this argument over to preserve the Chevron Doctrine, which we do not want preserved because Chevron Doctrine allows agencies like the ATF to simply say, you must embrace what we say. It's called the divine right of deference, really, if you will. Not the divine right of kings, but the divine right of deference. When in doubt, you must defer to our interpretation of the law because we're administrative agencies and we're the experts. And here is where it blew up on the Department of Justice today. They argued that it is better and wiser public policy and wiser all the way around for the experts, the experts in a particular area, like the experts in food and drug to make decisions about what the statute means in the food and drug context, or experts in guns, although ATF did not specifically come up that I heard, but the concept is that because ATF are the expert in guns, anything they say about the gun industry, the gun technology, and so on should be deferred to. And that was a big argument that the Solicitor General made today, that we should defer to the expertise of these administrative agencies whose entire existence and entire job is to spend their time studying these industries that they regulate. But then they got blown up. Here's how they got blown up. Justice Gorsuch said, wait a minute. What is this case about today? This case is about fisher. It's about fish, right? Fish, counting fish catches and fishing hauls and all that on a boat. And then he goes on to say, well, the question presented here is, under the statute, who has to pay the bill? Who has to pay the bill for the government employee monitors that come onto these private boats, private ships, to catch and monitor the fish take? So Judge Gorsuch says, in light of that, what exactly do you need to know? And I'm paraphrasing here, of course. What exactly is it about being an expert in fish and oceans that would somehow require us as a court to give you deference about who should pay the bill? What does paying the bill for federal monitors on a boat have? What exactly does that have to do with the expertise of being intellectual giants about fish and catching fish and fishing boats? Nothing to do with the price of tea in China, was essentially what Justice Gorsuch was saying. You could almost see, you couldn't see it on the tape, but almost hear his eyes rolling as he made his observation against the Department of Justice. So the bottom line is this: I think, as I predicted many months ago, when the Supreme Court decided that here in this case, they are going to knock out the Chevron Doctrine. This is hugely great news for anyone that has to deal with the ATF, including FFLs, because you know and I know, and I'm not an FFL lawyer, but I can tell you from the people I've spoken to in and around the industry that every single time to get into a fight about the bound book or how to understand some interpretation involving the ATF or some statute, inevitably the ATF invokes the divine right of deference by citing to Chevron. If the Chevron Doctrine is knocked out and no longer good law, that divine right of deference will no longer be the law of the land, and it will no longer be a stick upon which organizations, agencies like the ATF can hit industry over the head with, and that, frankly, is good news, not just for American gun owners, the Second Amendment, constitutionalism, and the separation of powers in this country. It's simply good, practical common sense and good for freedom in America. So there you have it. I'll probably give you a few more videos about this down the road. But in the meantime, hope you learned something here today at the 4 Boxes Diner. Make sure you follow me on X at 4 Boxes Diner. Please subscribe and resubscribe. People have been getting knocked off the list, so I've been told. And again, we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.